Maintenance of a child is primarily the duty of the father. The father is responsible for the maintenance and residence of the child in accordance with what is customarily good. The father is also responsible for the breastfeeding expenses of the child where the mother is not breastfeeding the child. The maintenance of the child is obligatory till the age of majority of the child, and even after that, where the child is economically or physically handicapped or chronically ill. In the case of a female child, maintenance is obligatory even after the age of majority, where the father is unable to maintain his child and the mother has the means to do so. She is to spend on the child but is given the right to recover from the father when he enjoys financial ease. If the husband is prevented from earning due to a handicap, she cannot recover from him. The mother of the child cannot be compelled to breastfeed the infant, where the mother of the child refuses to breastfeed the child. The father is to make alternative arrangements for breastfeeding till the age of weaning of the child. Nevertheless, the fatwa is that she should feed the child to prevent injury to it. Today, people prefer to bottle feed their babies, especially where the mother does not wish to breastfeed the infant or she cannot do so due to a physical difficulty. If the woman is physically able to feed the child, but chooses not to do so, the father cannot compel her to breastfeed the child. In such a case, he may hire the services of a wet nurse without the consent of the mother. However, he has to provide such services at the location where the mother resides, as bringing up the child is her responsibility. Where the mother breastfeeds the child, while she is still married to the child's father, she is not entitled to additional expenses for breastfeeding besides her normal expenses of maintenance, clothing, and residence. If the mother, who has been divorced, continues to breastfeed the child in her custody, she is to be paid expenses for such breastfeeding. This does not apply to the case of the revocable divorce. In all these cases, and even after the waiting period, the husband retains the right to hire another woman for wet nursing. In all the cases that we have mentioned, maintenance is obligatory upon the father where the minor does not have wealth of his own. If, however, he does have wealth, then the rule is that the maintenance of a human being is from his own wealth, whether he is a minor or a major. It is obligatory upon a person to maintain and support his relatives, who fall within the prohibited degree for marriage, when they are in need. This duty grants an enforceable right to the relatives, and they can approach the court for their maintenance, residence, and clothing expenses. The duty relates to the provision of expenses, residence, and clothing as needed. The duty for expenses and clothing remains even if such relatives own a house and employ a servant. They are not to be compelled to sell their house. Past claims not recovered do not become a debt in this case. The following relatives can acquire this right. First come parents and grandparents. The children are duty-bound to support their parents. If there is one child, an entire burden falls upon that child. If there are more than one, the burden is distributed among the sons. And if one is not able to pay, the others will pay on their behalf and will have recourse to him when he enjoys financial ease. Where there are no sons, or the sons are unable to support the parents, the duty falls upon the daughter or daughters as the case may be. The same rules apply to paternal grandparents and maternal grandparents when they do not have male children or their children to support them. The next category is that of brothers, sisters, nephews, and nieces. It is the duty of a person to support his or her brothers and sisters if they are in need. The duty moves on to the nephews and nieces if there is no one else to support them. The third category is that of uncles and aunts, whether maternal or paternal. It is the duty of a person to support his or her uncles and aunts, whether maternal or paternal, when they are in need and do not have their own children or their children cannot support them due to financial hardship. The general rule is that the duty first falls upon persons closer for purposes of inheritance. If they cannot pay due to financial hardship, the duty devolves upon those next in line, but they can recover from those prior if and when they regain financial ease. There is no duty to provide maintenance for relatives who are not within the prohibited degree of marriage. This rule will include first cousins, whether paternal or maternal, and those more remote.